I also want to mention that we have Joel Riedenberg and Doron Ben-Atar, who are scholars here at Fordham, and they are co-convening the seminars. Doron is the acting chair of history, and Joel is a professor of law, and he runs a research center on
Law and Information Policy.
Law and Information Policy here at Fordham. So we're honored to be connected to Fordham and to these two scholars. You ready? Joel Riedenberg from Law School. Thank you.
Thanks, Charles.
So I am delighted to get a chance to introduce Alex for tonight's lecture. We're really excited to have this second event in the series here at Fordham. Alex Tsesis is an associate professor of law at Loyola. He teaches constitutional law, civil procedure, seminars devoted to civil rights issues. He's published numerous books, Oxford University Press, Yale University Press, NYU Press, in this field, dealing with speech and hate speech and anti-Semitism. He's really one of the country's leading thinkers, particularly legal thinkers, on these issues. This is not the first time he has spoken at Fordham. We had the pleasure of having him at a conference that my center ran several years ago on hate versus democracy on the internet. So I can assure you we will be in for a great treat hearing him speak this evening. Alex, thank you.
Thank you, Joel. Joel, thank you so much for that generous welcome, and thanks to Charles and Doron also for inviting me. Interestingly, Joel and my family hail from the same city in what is now part of Moldavia, in Kamenets-Podolsk, and they have the horrible misfortune of both of our families having been murdered in the massacre of Kamenets-Podolsk. Even though our families, from what we can gather from having asked around, did not know each other, but it was really the first massacre that encompassed five-figure murders by the Nazis coming into the Soviet Union, far, far on the west. I want to speak to you about the differing approaches in the United States and Europe in regulating anti-Semitic speech. The distinct approaches are partly there because of the unique histories with obviously more virulent and more sustained anti-Semitism in Europe and in Arabic countries than it is here in the United States. And even today, the anti-Semitism emanating from those regions is, of course, even more menacing than its counterpart here. Despite these differences, I want to try to demonstrate this evening that there is just as much principled reason to regulate hate speech here in the United States, and particularly as it affects Jews and anti-Semitism, as there is abroad. It's a very controversial subject. I don't know if any of you saw the story today in the New York Times that Twitter has pulled the account of a Hanover hate group that the German government asked it to completely take down their website. Despite Germany's request, or because of Germany's request, I should say, Twitter has decided to prevent their account from going, this hate group's account, from going into Germany, but has continued it into other places in the world. So really, it's accessible everywhere. So it's very controversial. If you read the New York Times article, you'll see that the reporter is very, very antagonistic towards this, thinks that it's a major impediment to free speech, and looking at the comments that people saw, I only went through a couple of them, but they're much supportive of that view. My remarks will specifically focus on the ideological differences in the approaches on free speech here and elsewhere. In the United States, academics and politicians have focused on a more libertarian point of view than in Europe. Their emphasis is typically on the self-expressive worth of speech, while European and Canadian policies tend to show greater historical sensibility to the role of anti-Semitism in everything from pogroms to discrimination and exterminationism. The argument in the United States tends to place a greater emphasis on the individual interest to make offensive remarks and to downplay its potential to harm the targeted audience and society at large. European nations and Canada, on the other hand, are more likely to counterbalance the potential interests in speech with its likelihood or the likelihood of incitement against Jews to create a more pluralistic society. Let me put it a different way, that the regulations tend to further pluralism rather than to harm it, is the way that Europeans and Canadians think of it, where in the United States the thought is that we will actually harm democracy, and more specifically individual rights, if we were to regulate hate speech. The United States public policy then is much more differential to speakers, that even when they instigate hatred against minorities or Jews, their institutions, their practices, and their dignity, U.S. scholars and judges tend to downplay the centuries of tragic experience that Jews have experienced, of how their stereotypes against them have both reflected and influenced custom and law. European and Canadian lawmakers are more careful to guard against the risk that advocacy will turn into action. Penalizing hate speech, they believe, helps to institutionalize lessons about the tragic past in order to set necessary regulations against the aggravation of simmering prejudices. U.S. history is not without its own skeletons, and I'm thinking of such things as slavery as well as Native American relocation. And the potential for destructive statements are here just as much as they are in Europe, and I think they shouldn't be taken lightly, and that's going to be the subject of my talk this evening, where I'll discuss the differing approaches of anti-Semitic speech in various democracies around the world, and a comparative discussion that will draw in various rationales of national states have given for restricting various anti-Semitic groups. Countries that have adopted international pacts and domestic laws against speech widely agree that Nazi uses of slogans helped German leadership recruit, indoctrinate, and energize a broad following, making anti-Semitic speech not at all benign. In the United States, which is the approach I'm going to speak about during the second part of the lecture, unlike other nations around the world, the Supreme Court has clung to an antiquated concept of speech that's much more in line with social Darwinism than it is with historical reality. So first, just to begin with international norms. A variety of international pacts prohibit the instigation of unlawful conduct based on group defamation, hatred of Jews and various other minorities, that call for violence and try to get others to engage in the sort of discrimination that we all associate with anti-Semitism. Many, if not most, democracies around the globe, in fact all the ones that I'm aware of, recognize that hate propaganda helps to perpetuate ethnic strife and poses a threat to targeted groups. Laws against the dissemination of hate speech exist in democracies around the world, so in part in thinking about this argument that regulation of speech will harm democracies, well, it certainly hasn't harmed democracies in countries like Austria, Germany, Hungary, India, the Netherlands, Denmark, Sweden, Switzerland, and many other, France, and many other democracies around the world that have hate speech regulations. Those are thriving democracies. There's no reason to think that they will not continue to be, and they're very much committed to free speech despite their regulation of hate speech. European countries then are particularly sensitive to the potential of speech to turn into action, having seen the power of propaganda in the European theater during the Second World War. 3 years after the war, the United Nations General Assembly passed the Convention on the Prevention and Punishment of the Crime of Genocide, in which there is a provision that prohibits the instigation of genocide against Jews and other vulnerable peoples. In the hands of charismatic leaders, the thought is that these destructive messages that exist in this sort of political downgraded, not many people are interested, where a charismatic leader comes to power, can harness that and sustain that both for the purpose of retaining power and amassing it further, gathering followers who see something in common, this particular hatred, and as well as then turning it into action and taking it into what they think is the final solution in the most extreme case, or to just simply allow anti-Semitism to continue and for violence to occur as just a way for people to release steam and anger and find a common enemy rather than looking at the negative policies of the state. The United States at first had reservations about this declaration, and particularly it did not want to enter into the part about instigation, but has since, in passing the Genocide Convention Implementation Act. This is a U.S. law. As far as I can tell from I've done an exhaustive search of it. Certainly there are no reported cases of any uses of this part of the Genocide Act to prosecute anyone for the instigation of genocide. We know that the Act, obviously, the Convention Against Genocide and the Punishment of Genocide, has not stopped these things from occurring. And if we look around the world, we look at, for example, the dehumanizing rhetoric in Rwanda by the Hutus against the Tutsis, calling them cockroaches, amongst other things, has also played a very important role in generating genocide in that country. And the Khmer Rouge, obviously, is another political form of mass violence that has happened since that convention. Well, other conventions that are out there that have this anti-instigation component include the UN Convention on the Elimination of All Forms of Racial Discrimination. This Convention Against the Elimination of All Forms of Racial Discrimination was passed in 1960 after a series of anti-Semitic events around the world. It was well recognized during debates on this convention that what was going on was that there was this increase in anti-Semitism so short a time, just 15 years after the end of World War II, with mass media coverage in the very early days of what had happened in the Nazi concentration camps. And so one of the articles, in Article 4 of the convention, commits governments who are parties to this convention to both declare it a punishable offense to disseminate ideas of racial superiority, and to declare it illegal and prohibit organizations which organize and propagandize on the basis of these supremacist ideals. And there are other countries as well, other conventions as well. The continuing effort to fight anti-Semitism, xenophobia, and other forms of racism by European nations has increasingly incorporated these conventions into their domestic law. So what they've done with these is that these, as I said in that Convention on the Elimination of Racial Discrimination, it's not that it actually created a right of action, but rather that it required those who covenant to the convention to make such laws. And European countries have done exactly that. So in Austria, where just recently, in August of this year, a very violent attack occurred, including Nazi salutes and statements about Jews need to go back to their own country. There is a penal code that enforces this, that enforces a law against the instigation of anti-Semitism and other forms of racial discrimination. The way that Austria looks at it is that it's part of public order against inciting hostilities against religious, ethnic, nationality, and racial minorities, with the underlying purpose being the prohibition of slander and the attack of human dignity. This is a very important distinction between European laws in that they tend to place emphasis on human dignity in a way that United States legal academics often throw up their hands and say we don't really know what dignity is. Of course, we don't really, even try to define concepts like liberty or due process or rights. Those are all very, very ambiguous, but for some reason they have a particularly difficult time with dignity, which is just as ambiguous as any of those that we consider to be the bastions of our fundamental rights. Some countries with a very long history of anti-Semitism have laws against the sale of Nazi paraphernalia. So for example, in a very famous case that you may have heard of because it's been out there for quite a while, in France, a French court required Google to prohibit contact by an internet service provider, Yahoo. I hope I'm saying it's internet service provider, search engine, internet search,
case.
Yahoo, yeah, the Yahoo.
What was their auction site?
The auctions were coming through Yahoo. You could search for Nazi paraphernalia and you could buy it in France. This is against French law. Yahoo said it could not stop this material from going to France. The judge ordered it to stop, and in fact, evidence by experts showed that you could see that Yahoo could actually stop the sale of that memorabilia specifically into France in the same way that I just mentioned about Twitter stopping the account of this anti-Semitic group going into specifically Germany. And Yahoo, in fact, stopped doing that because there was a sanction. The judge said that if you don't prevent this, every day there's going to be a fine. Yahoo challenged this in federal court in the United States, but on various procedural grounds, not on substance. It was not, nothing was decided about the speech component of this, but on procedural grounds it was dismissed. So Yahoo stopped this based on French law. The French court was obviously requiring Yahoo to abide by French law. Right? These are multinational corporations that really want to run, that really want to operate without having to abide by any national laws and to use the most liberal laws on speech, which are really in the United States. Likewise, the Canadian Human Rights Commission ordered a white supremacist and Holocaust denier, Ernst Zundel, to remove anti-Semitic statements from his websites, even though it was being operated from California, but it was being sent into Canada. In California, of course, it was legal to disseminate this information, protected by the First Amendment. The Commission found it enough that Zundel's website was received in Canada to find that there was an offense, and that granted authority to the court to enforce Canadian laws. Right? Not only just because you might think there are different ways you could enforce law. You could say, well, if the illegal action occurs in our country, then we can enforce law. You could say if it occurs in the country or if its effect is in our country, either way we can enforce the law, and that's what the Canadian court did. That's what the French court did before it. German courts, like the French and Canadian counterparts, have also recognized that democratic society has an obligation to hold persons responsible for spreading hateful messages into Germany from outside its borders. So just 3 years ago, in 2009, Germany requested that a foreign internet provider bar websites that promote neo-Nazi ideology. It didn't order them to prevent this, but it asked them to do so, which is already making a communicative effect about Germany's commitment against anti-Semitism. Germany's memory of the real risks that can result from inflaming long-established hatreds and stereotypes, and the ease with which they can be incorporated into political rhetoric, have translated into policies that counterbalance the risk to a democracy and the high value it puts on speech. So it balances things out. The U.S. courts, just in very recent, in 3 recent Supreme Court opinions in the last about year and a half to 2 years, have prohibited the balancing of any other social value with the value of speech. They become extremely categorical. In Germany, on the other hand, there is a clear balance, because Article 1 of the German Constitution is about dignity. And then the other provisions deal with speech, and German courts allow for the balancing of speech with human dignity as well as the right to retain democracy, because after all, Hitler came to power in a democracy, and Germany's well aware of that lesson. So Germany's protection of democratic order and the dignity of others has led it to prevent incitement of hatreds against particular segments of the population, advocating violence and discrimination against them, and insulting them and exposing them to malicious contempt and slander. The persistence of anti-Semitism and xenophobia in Germany, despite the horrific lessons of the Holocaust, have also led to the codification of prohibitions against the abuse of expression, free speech, teaching, the right of assembly, and association, all critical rights in Germany, essential rights to democracy, but ones that can be limited in order to prevent democracy, as it was in Weimar, from moving into autocracy. In Germany, as in many other European countries, there has been an increasing number of instigations and perpetrations of anti-Semitic acts. In one recent attack, Rabbi Daniel Alter was recognized as a Jew for wearing a yarmulke and was attacked by several Arab men in something that was quite publicized in Germany and around the world. In an attempt to curb the existing far-right parties, like the party in the Twitter issue that I mentioned earlier, there's also another major one called the National Democratic Party, the NPD is its acronym, in German. The German Interior Ministry has been investigating them in trying to exercise a provision of its law that prohibits the dissemination of anti-democratic speech, and it's amassed over 1,000 pages of documents about their activities and anti-Semitism that's trying to move forward. It's very, very slow. And it's very slow because of the commitment to democracy. And when you think about it, for example, compared to the Israeli model, Israel also has a law that prohibits anti-democratic parties from participating in the Knesset. The only group it's ever exercised that against is Kach. So why? Because it wants to be exceedingly careful. Not because it doesn't recognize there's hatred from other sectors of society, but rather because, just as in Germany, there's great care being taken care of. And these regulations are making a statement about the commitment of society against bigotry, but they are not really leading to a road of perdition and the end of free speech in the way that you see in U.S. media and you usually hear from First Amendment academics. The United States takes a substantially different approach to incitement than European countries that I've just reviewed. To begin, the United States valuation of speech is in every way places just as much import. It values it just as much as Germany, Austria, France, and Canada, who I just spoke about. What's different is a much more limited approach to regulation on hate speech in the United States than in Europe. The U.S. Supreme Court has often stifled the creation of laws that prohibit hateful incitement. And the court's recent decision, which I mentioned, prohibit this balancing of speech against other social values. So that provides the opportunity for groups to disseminate hate from the U.S., which they cannot do elsewhere, which is why Zundel was here trying to use this as a forum for his website. And most hate groups' websites come out of the United States because of the First Amendment. So they exploit First Amendment protections. It's not that they're committed to free speech, right? These xenophobic, anti-Semitic groups. It's not that they're in the United States because of the deep commitment to U.S. values. They're here to exploit the low laxness with which we prosecute these things. Current First Amendment doctrine rejects the constitutionality of any regulations on the content of speech, except those that the court has found to be traditional forms of prescription. Now, this concept that the court can figure out only traditional forms of prescription allows it to have a lot of latitude and subjectivity by the members of the court of what they think is traditional. Surely they don't think the Alien and Sedition Act is traditional, but that's really where tradition is. First Amendment tradition is quite different than what it is today, but the court is using this traditional approach. In practice, this means that a variety of expressive conducts, like Holocaust denial, are protected currently by First Amendment doctrine, unlike in other democratic countries. The different approaches to inflammatory speech arise from a unique national and cultural experience. Europe is obviously more aware of the extreme destruction that often follows on the heels of anti-Semitism. The United States is not immune to anti-Semitism. There were events in the United States like, very well-publicized thing about the Ivy Leagues keeping Jews out. But it's obviously not reared its head to the same extent that it did in Europe. The pogroms, the attempted genocides obviously have not happened here. The case of Canada is different. So where we can look at Germany and Austria and France, and we can see a clear past where there was either Nazis that were actually there, or in the case of Vichy, Nazis in half of the country or sympathizers. In Canada, there also has not been this strong anti-Semitic culture. McGill, by the way, where ISGAP is now has a program, wonderful events going on there. Also excluded Jews, but obviously is now taking a major about face, hosting ISGAP amongst the major. Okay, it has changed somewhat. Let me leave that ambiguity, not knowing more. But it would be really an unfair stretch to impute to Canada the same cultural anti-Semitism that drove the masses of Europeans to commit so much disparagement, discrimination, and violence against Jews over the course of centuries. Unlike anti-incitement laws in Europe, therefore, Canada's policy against the dissemination of anti-Semitic and other hate speech cannot be explained as a response to the shocking extremes of domestic depravity. The Supreme Court in Canada has explained this curtailment of ethnic incitement as a predicate to the country's commitment to democracy and pluralistic values. So there is this, a great, in Canada, Canada's thought tends to be pluralism, multiculturalism. In Germany, the explanation tends to be the retention of democracy. In Austria, it tends to be dignity, and in fact, all these countries have this, Germany and Canada as well, the Supreme Court and the statutes and the constitutions speak in various countries in various places in their laws speak of these concepts of dignity. Dignity is very common, but the emphasis in Canada tends to be pluralism, multiculturalism, and in German, democracy. Contrary to international consensus that hate speech poses a threat, there remains a widely held belief in the United States, which is particularly common, as I say, in the media and amongst academics, that the expression of animosity towards specific groups is naught but cathartic. Allowing people to express their desire to harm groups, so the thought goes, is just letting off steam. It diminishes the risk of action. This is a pressure gap type of explanation. Long ago, Gordon Allport, the great psychologist of hatred, said that there's never a bite before there is a bark. That the bite always comes after the bark, but the bark comes before the bite. This mistaken belief that letting off steam will be sufficient for hate groups, that's all they really need. They just want to let go of their feelings. If they could just do that, we could prevent them from acting violently. Is often coupled with the view that democratic institutions are furthered by leniency toward the expression of group defamation. While the concern of hate speech will inhibit free expression of ideas is obviously very laudable, it goes against what we do in many other areas. So there are lots of limitations on speech that are not thought to be anti-democratic, and in fact are thought to be democratic. One is, for example, the protection of copyrighted material. Right? Copyrighted material is protected through a very content-rich analysis. You have to look at the content of the material that's copyrighted. You have to see what the copy is. You have to determine whether the form and the material in the copyrighted material is the same as the others. That's just nothing but content-rich. The idea that you cannot pretend to be an attorney, you cannot fraudulently say you're a physician. If you can't examine the content of what somebody is saying, you can't figure out whether or not they're feloniously acting like an attorney or a lawyer. So we use content limitations. But for this hate speech, there's a very insular concept that the U.S. has got it right and European countries have it wrong. Moreover, the pluralistic values that democracies have in regulating hate speech in Canada and France and other countries certainly don't seem to be weaker, as I said, from these regulations, as I mentioned earlier. Indeed, the exceptions to the seemingly categorical U.S. restriction on content regulations on speech undermines the safety valve and democratic commitment arguments. While it's easy for somebody to say something like, my expressive speech, my liberty to be able to speak, allows me to open up a pornographic theater in a residential district, we say no, you can have certain limitations on speech that limit your expressive ability. Another thing is that the United States Supreme Court has recognized that limitations can be placed that nobody can campaign, no one can politicize 100 feet away from a polling place where you vote on the day of election. 100 feet from a polling place, if a state wants to prohibit that, it can't. Now, we all know that voting is both cathartic and democratic. And yet here is a position where it seems like we're balancing the social value of politics and people's ability to go in the polling booth and not feel like they're being pushed by somebody against the right of the guy who wants to stand there and politicize. He too has a right, he too has a liberty right, but there are legitimate limitations that can be placed on him. The same is true about deceptive and misleading uses of trade names, also something that has to be examined and where there was a value. And that value, just as in copyright, we think actually furthers and promotes self-expression, just as Canada thinks it promotes multiculturalism, that it puts certain restraints on anti-Semitic and other forms of hate speech. Historically, hate speech in the United States has not enjoyed any protections, and this doctrinal stand comes from a case called Brandenburg versus Ohio, that said that only speech that is imminently threatening, that is to say there's a clear and present danger, it's going to happen right away, can be regulated. This granted hate speakers the same sort of rights that other political speakers had. It sort of legitimized hate speech as being just another form of political vitriol or political statement. Such a legal paradigm ignored the historical lessons about the power of hateful incitement. Lessons that European countries had internalized in the aftermath of the Holocaust, with, for instance, the Convention on the Prevention of Genocide. The evolution of anti-Semitic propaganda in Germany during the 19th century, which began with Adolf Stoker in 1879 being the first German politician who was able to effectively use anti-Semitism to win political office, right? He just went in, he was losing the campaign until he began speaking against anti-Semitism to the middle class, to the Mittelstand. He saw the response he got, he adopted it, and he won a seat. And that Wilhelm Marr, who created the term Antisemitismus, which was supposed to be an umbrella term, a positive term, anti-Semitism, that would help political groups join together so that it would give them common power in the Reichstag, were very ineffective during the 19th century. They won very few seats. It was only after statements made in Germany during the 19th century, like the Jews are our misfortune, by the great German historian Trischke, and Judenfrei, Jew-free, which had very little significance until the Nazi Party and other parties as well took that as their slogans, and they had seeped into the culture. They were easily recognized. They were no longer new. They were no longer fresh, and they were dangerous, and exploited these hatreds to come to power, winning not only when you count the votes in the 1932 election, which brought the Nazi Party as being the majority in the Reichstag, along with the Catholic Center Party, the German National People's Party, and the Bavarian People's Party. The majority of parties were committed to anti-Semitism in 1932. But if you look at the German election results of these of anti-Semitic parties in the early part of the 20th century, they had virtually no power. They were laughable. They were not taken seriously. So it took time for anti-Semitism, which of course had deeper cultural roots in Germany than it does in the US, to grow into a major political movement. The United States might not only learn from the European experience, but also be influenced by the anti-Semitic slogan's ability to instigate evil from what has happened in its own experience with the long-term effect of hate speech. Here, anti-black statements were critical to the development of pro-slavery thought, the gathering and the strengthening of John Calhoun and Governor Weiss in Virginia, if you look at the early part of the 19th century, people were apologetic. They excused having slaves. In the 18th century, people like Patrick Henry, Jefferson were embarrassed of having slaves. By the 1830s, the pro-slavery rhetoric had taken hold. It took years, it took decades. And the same is true of the savage image of Native Americans, which caused Native American displacement, which also had almost no effect in the 17th century when Native Americans were ordinary trading partners of the new colonists. But in time, these images of them not owning land, and not having legitimate rights to possess property because of matriarchies and other reasons, wound up being excuses for misappropriating the lands. In one positive development just recently, in a case called Virginia v. Black, the Supreme Court showed an increased recognition that cross-burning can be truly threatening. This was a big change because there was no imminent threat of harm component. It's a case that's been almost ignored in the literature, unfortunately. And it essentially said that when the Ku Klux Klan rallies occur outside where the public can see them, and their crosses are burned with the intent to intimidate, then states can have criminal laws that punish and prohibit such public conduct. A practical application of that rule made it possible for law enforcement agents to prevent gradual cultural infestation of anti-Semitism, racism, and bigotry of other types that that grew in Germany, as I mentioned. However, where a burning cross is displayed in private, that still is something that is going to be governed by the Brandenburg test of imminence and allowed. But that's really, frankly, true in other countries as well, like England, where a private display of hate symbols is not prohibited. Now, just as the court found that the history of the cross held a certain virulence to it that could be intentionally used to instigate, I think that it should also be extended to other symbols like Hamas flags, Hezbollah flags, and swastikas. The court hasn't done it. We don't really know whether they will. They could argue that those are symbols from other countries, but I think the connection of terror, if you take Ku Klux Klan to be a terror group, are similar, and that this case, Virginia v. Black, the holding should be extended to those symbols as well. So in conclusion, there remains a significant difference between the way that the US and European countries approach anti-Semitic speech, and frankly, there's little possibility that there's going to be a resolution anytime in the future, with the Supreme Court now prohibiting the balancing of free speech from other social values. Until the US begins to vigorously implement international protocols prohibiting the disparagement of groups, Holocaust deniers and anti-Semitic bloggers will continue to exploit US territory to spread stereotypes and propaganda meant to degrade Jews and to justify the commission of illegal conduct against them. Besides the threats approach, which is what that Virginia v. Black case took, that another approach might be to revive the group defamation statutes. European countries use these group defamations. They recognize that a statement about the inexistence of the Holocaust is a false statement, that it's not a true statement, and therefore not protected by the same democratic values that are at the core of free speech in the countries that I mentioned from Europe. The Supreme Court has long recognized this group defamation doctrine. It's mentioned it in a couple of opinions, but it's something that most scholars say is no longer in effect. It has not been enforced for many years, but I think that people can try to revive it. As I say, the Supreme Court continues to cite to it as a legitimate doctrine, but it has not been tested in the near past. As things stand, neo-Nazi groups that seek to elude European prosecution rely on U.S. internet platforms to spread their anti-Semitic programs. It's time to look for ways to bring the U.S. in line with other democracies and to diminish the spread and effectiveness of anti-Semitism here and abroad. Thank you so much for that. glad to entertain any questions or comments, insights on your part. Yes.
Let me be devil's advocate for a moment. What would you say to people who argue that, it's long been known that when you prohibit something, it becomes attractive? That perhaps not prohibiting it, but let's compare how Jews feel in the countries that have those laws that suppress hate speech versus how they feel in countries that don't. Now, I realize there are many factors involved, but it seems to me that you could make a case that Jews are more comfortable in a country like the United States where that kind of speech is not suppressed than they are in many of these European countries that do suppress that hate speech. So, could you deal with that point?
Sure. I think it's a very good point. So I think a couple of things there. One is the attractiveness standpoint, that if you make something illegal, let me just jot down so I make sure to answer all of your points. So the attractiveness point. I think that point could be made about any sort of criminal law, right? Date rape laws. Maybe a person has never thought about date rape, but here's a date rape law that thinks, oh, date rape, okay, well, here's an easy victim, I'm in this room, I'm completely alone, it's an easy victim. The same is true of all manner of other laws, right? Copyright violation, maybe, someone doesn't think about trademark violation. I mean, all sorts of crimes, people say that from sitting in jail, they often learn about crimes they never thought of. And so that often, by putting people in jail, one of the arguments that people have made about the reduction of the time that we sit people in jail, and also have argued for an increase in rehabilitation as opposed to punishment, is that we put these people in jail with the people who are criminals, and they begin to learn crimes they just never thought about. They learn methods of doing breaking and entering, where they never realized it. Someone tells them, well, what you do is you look at a house and you sit outside it, and here's the way you case the joint, and here are the tools you use. So I think, this could be really said about any sort of law. I think to the contrary, that what it does is it communicates a nation's disapprobation. So I think these laws should be used extremely rarely. Speech is too important for us to jump in like date rape or murder or something like that, and just to prosecute left and right. Not at all. These should be used very hesitantly. But we should be conscious of the fact that we are a democracy now is no promise that this will happen forever. In fact, we were not a democracy as far as women, as far as blacks, as far as many different groups in our history as well. And so another argument that's along the lines of what you've said that's made is that we give these groups a platform. For instance, there was a guy, an Aboriginal leader in Canada who was prosecuted, convicted, and then eventually appealed and acquitted. And people said, look, if he had made these anti-Semitic statements, if he just didn't prosecute him, people would have forgotten what he said. And he was acquitted eventually, after all, right? But the thing is, Canada made a statement that it will not tolerate that is not part of its society. So that in and of itself was worth it, because a Jew or any other person of any other group can go to Canada and feel that he has the country as a legal entity on his side in case somebody scrawls something. It's not definitive, and your view is a very legitimate one, but that's my response to it. Sorry, back there.
Yeah, most of the examples that you gave of countries with laws that are in place that you think of as examples of what the U.S. should do, they've been in place for 50 to 60 years at most. Any examples you can give that have been in place for a much longer period of time that have stood the test of time, and then what do you think the downside? What are the risks to those laws that just play another side? I mean, given one side of the what's the risks to those laws that the governments have used those laws? So two questions.
There are no longer precedents than those that I'm aware of. I mean, they could be out there. I've never researched it to see what was there before the Second World War. But the thought is that really it was the Genocide Convention that began this, and that it was while it was always the case that there were xenophobic points of views that drummed up people and dehumanized the other and allowed for people to slaughter and to butcher other human beings, looking them right in the eye and thinking of them as not being human, that it was really the mass atrocities of the Holocaust and the effectiveness of the Nazi machine to use that propaganda that led to the Genocide Convention. And then it really was the creation of the UN also, and that these countries committed themselves that they would make these laws. So I'm unaware of any other examples. The downside, right? The upside is they prosecuted a variety of groups. The downside, I mean, to make the counter argument to my point, is that you could say, some people say that hate speech laws, just like hate crimes laws, tend to target minorities. So they'll say, for instance, that that groups that are considered the other, gays and lesbians, for example, tend to be targeted because people don't think of that as normal behavior, or that hate crimes laws, which is also analogous or similar to hate speech laws, are more used towards minorities. I don't really don't buy into that, because I think that if there's anti-Semitism coming from Farrakhan, it's just as bad as anti-Semitism coming from David Duke. And you prosecute whoever you prosecute, right? Where there's abuse of the system, there's abuse of disorderly conduct ordinances, with most sweeps occurring in black neighborhoods. But does that mean, if there's a particular targeting that's of groups that are meant to be protected by these laws, then there would be something that's legitimate. But it seems too abstract an argument. I guess another argument against this is that it doubles down free speech and might later cause diminution of speech in other areas. That just hasn't happened with such things as harassment laws in the workplace, right? You could say Title VII, which perhaps prohibits sexual harassment, so I can't put Playboy centerfold in my cubicle at work because people, if it offends people, you could say, well, it diminishes my ability to free speech, other people's free speech. But we just don't think of that as a society. We think that other people have certain rights and sensitivities that we should honor, even if it's a minority of those people. Again, I see the other side. I think it's a completely legitimate argument, but I think that there are strong arguments here. I think you had a question.
Well, it's about hate crime legislation,
But do you want us anything else, anything further?
No, I'm fine.
So I think there are motivation issues there. Those are the difficulties. I think Joel had his hand up, then Charles, and here, and then yeah.
So I have one radically provocative question, and then, if I could, two related ones. The radically provocative one is following up on your comments on Virginia versus Black.
Could you repeat that?
Yeah, so it's my radically provocative one is thinking about the comments on Virginia versus Black, which was the cross burning could be seen as imminently threatening.
Or true threat.
Or true threat. Would that suggest that the Jewish community should act far more aggressively when anti-Semitic speech is made in a way that makes it clear that that kind of speech would create an imminent risk of violence? That's the provocative. The second is, I thought about your comments on that the U.S. is rejecting any kind of balancing of social values. And I wonder if there might not be, going forward, a way of looking at balancing within the First Amendment itself. Because the First Amendment also has freedom of association.
Mm-hmm.
And I wonder that to the extent that you could make arguments, anti-Semitic speech, the impact of that, the incitement created by that, is harmful is harmful to the associational rights of the Jewish community. And to that extent, and this is where I think Charles comes in, if that kind of argument could be made, it would suggest a very fruitful research avenue for researchers to look into the impact on Jewish groups from anti-Semitic speech. And I think of the impact on campuses, for example. You have very aggressive organizations on campus attacking Jews in the Jewish community. If you can research and demonstrate what's the impact on Jewish students on campus, that it's impeding their associational freedoms, whether that might be a way of getting it.
Mm-hmm. That's great. Let me pick up on that. It just because it was the question we just had, so it's nice to transition with it. I think that's spectacular, and in fact, the way that those cases are drafted, that say you can't balance free speech against other social values. I actually have an article. I'm going to attack that. I mean, I was just thinking on the flight here. Boy, what am I going to do? I got working on these things in here, and I got a little space. This would be nice to do. Is to say to balance it with constitutional values rather than social values, right? So the way, so I had not thought of association. I had not thought of it. That you just added. I was thinking about equality, travel. Right, travel is also one about.
Yeah.
I mean, it's also not written. It's not explicitly in the Constitution. Association, by the way, is not explicitly in the Constitution. Right, it's an implied First Amendment right, and equality is there. And so maybe the way to go from the court is to say, well, you can balance it against other constitutional rights.
You have right to peaceable assembly is explicitly stated in the First Amendment.
Yeah.
And if what happens to a campus group is because of the assertiveness, the Jewish groups can't peaceably assemble.
Right, absolutely. Or can't go on a certain part of campus, right? Because it's got some wall and, it's making those very Jewish anti-Semitic stereotype. So I think that's fantastic. If I ever write that, you will definitely get the acknowledgement that you deserve.
That's so important for your
and I'll
career,
send it
isn't
to you. It's more my reward for coming, actually. The other point about Virginia v. Black, the first point you made, so it does not use imminent threat of harm. The amazing thing is it's a true threats doctrine that comes from that case with the Johnson, that threat made supposedly against Lyndon Johnson, where they upheld the true threats statute. All it said was that you had to prove intent to intimidate. That's very common with the European laws as well. It's very protective of speech, and it's necessary to be protective to prove up beyond a reasonable doubt there's an intent to intimidate and protect free speech rights, and yet we'll go after groups that are like Stormfront or Ku Klux Klan, Hamas, Hezbollah, that are very obvious in what they're doing. And with that, you don't have to provoke, right? You can just say, look, we perceive this as a true, we are reasonable people who perceive this as a true threat. And in fact, the difficulty would be proving up the intent, like it always is, the scienter element. So I think Charles had his hand up next, and then I'm sorry, I don't know your name, but you're next, and then Dorian, and then somebody else had his hand up next, so I'll try to keep track of the order. Yeah.
So I just want to comment on the notion of freedom of expression. So in the Canadian context, there's freedom of expression, freedom of speech. There's also freedom of promise. I think that's a very important distinction in Canadian law. And also, in a sense, I think the whole notion of citizenship is very different in a place like Canada compared to the United States. The social contract is much more robust. So healthcare, education are seen as rights, not privileges. And protecting the citizen is an integral part of the legal system, and I think just being a member of a society with that social contract. I don't know if citizenship plays a role in these issues as well. And now for a second thought, to bring it back to contemporary anti-Semitism. And first of all, I want to thank you for the paper. It was a very rich, thought-provoking paper. Contemporary anti-Semitism, in a sense, I would argue, everybody certainly agrees, but contemporary anti-Semitism at the core, I would say, is sort of the demonization of Israel, and via the demonization of Israel, Jewish communities in the diaspora that are supporting this racist apartheid, colonial entity. Radical political Islam has at its core a genocidal anti-Semitism, which is clear. It's part of its theology, it's part of its military policies, it's part of its political speech and aspirations. It's clear and unequivocal and open and honest and in your face. Kawadari, the spiritual head of the Egyptian government, regime, whatever you want to call it, literally led a prayer calling for the extermination of Jews. Morsi doesn't do anything without adhering to his religious views. And in the West and in the academy, there's the acquiescence for all sorts of reasons to this threat. The United States is the greatest purveyor of this anti-Semitic hatred through the internet in the world. This is where all the domains are, well, many of the domains are registered, and a lot of the internet traffic, which is playing an important role in disseminating this hatred, comes through the United States or is disseminated from the United States. The United States, in terms of, you spoke about the Convention on the Prevention and Punishment of Genocide, is a signatory to that convention and is obligated to prosecute or bring people to tribunals who are violating the convention. And of course, it's never been done for the prevention in Article 4. As a legal scholar, if what I'm saying is true in terms of its anti-Semitism, the genocidal anti-Semitism, I don't think we need to be so worried politically. Maybe the legal jurisprudence and the importance of the past cases of the president. I'm not a legal scholar, and you are, is important. But politically, in terms of studying contemporary anti-Semitism, the process and the right-wing stuff in Idaho, or some guy opens a store in India with the name Hitler, it's not so important. Our administration here is funding the Muslim Brotherhood in the tune of billions of dollars. They're supporting all kinds of characters that are literally genocidal in their anti-Semitism. And yet, legally, the First Amendment guarantees all sorts of freedomization. What do we do? Is there a legal remedy? Is the government of the United States obligated to draw red lines on those who are inciting to exterminate people?
There is, I mentioned this. First of all, you said it much better than I did, so let me I won't be able to add a whole lot. There is this law that I mentioned, I'll be glad to give you the citation to it, it's in my paper, that it enables the U.S. commitment to the Genocide Convention. And so it obligates the prosecution of genocidal incitement, which would include what you've just mentioned. As I said, I've looked at all the extant cases, and nobody knows you've been prosecuted. There are other provisions of that act, they have been prosecuted, but not the one about incitement. So I think the way to go about that, although it's completely out of my hands, but you've got much more influence than me on this, because you've got many more connections in the amongst Jewish groups, is to try to get somebody to bring a test case, Simon Wiesenthal or somebody. Right?
If I can prove it, there's a body of information that shows that the Morsi government is inciting to genocide. Let's say I can prove it. Is the United States of America obligated to change policies?
It's not, because that's really the political question doctrine, right? So in terms of diplomacy, that you can't change. But in terms of prosecuting, what I was going more towards are if the domains are in this country and the actual incitement to genocide, gross incitement to genocide, explicit incitement to genocide is here, that I would think that the U.S. can go against. I'm unaware of it going against. Now, just a quick follow-up is your points about that these right-wing groups, Klan, neo-Nazis, and so on, have very little power and effect relative to the radical Islam. I absolutely agree with you. My limitation as a scholar is that I don't know Arabic, and so we have MEMRI, MEMRI, this website that translates things. But then I'm limited by what they provide as opposed to doing my own deep research, and so it's a shortcoming of my research, frankly, and of my writing. I just can't get at the material, and I'm much more closer to studying Yiddish than I am for another project about the Holocaust that I have in mind. So we need scholars to do this, and unfortunately, I just don't have the. We need probably Israeli scholars, frankly, because in Israel they study Arabic, right? So someone in Arabic needs to pick up that strand of thought and start reading this, and maybe they are, but I'm unaware of it. I'm sorry, Cindy.
Yeah, I was just kind of going to piggyback off what you just said, Charles. It seems to me that our approach to anti-Semitism of Jews isn't very effective. And when I look at people like Jesse Jackson and Al Sharpton, who I don't particularly admire, but I do admire the approach that they took to racism. It's been really quite effective. And then you look at Islamophobia, which I also think is bogus, but nonetheless it's been very impactful. These things, these approaches, they don't follow laws. They just are. They just put it out there, and they use fear, and they intimidate people so that you can't say anything racist, even if you choose to or want to. Islamophobia, you can't say anything negative about Muslims, even though most of us have a lot to say that's negative about Muslims. But yet, Jews, we're on the firing line. We are there. It's open season on Jews. We're not very well defended, and we are very scholarly, we are very intellectual people, we follow the laws, such as the discussion that we're having tonight. But do you think that maybe we need to incorporate another approach? Because look what is going on in our country. Look what's going on in Barack Obama's administration. He is engaging the Muslim Brotherhood, and the Muslim Brotherhood is virulently anti-Semitic. So why do we not need to incorporate a different approach, a different way of thinking, a different way of handling ourselves? Because anti-Semitism is on the rise. It's clearly on the rise.
Well, I mean, I think that we do have a different approach that we didn't have in World War II, which is Israel, right? So, you know, it's very troubling, actually. I was just in synagogue last Sabbath, and there's a prayer, it's slipping my mind what it is, and it talks about how we collectively as a group have this conscience. I apologize, I can't remember the prayer, and I'm not going to spark anyone's memory of it by just saying that. But I thought to myself, well, we have that feeling, but during World War II, that didn't help us very much. You know, when people walked into those pits, in Kamenets Podolsk, for example, which I began speaking about, where Joel and my family come from, our families, I should say, come from. You know, there was an account of a man, a Jew, the Nazis didn't realize was a Jew, driving, and he actually saw the slaughter, people getting into the pits and just walking up, and we've read these accounts, I'm sure all of us have, during the Holocaust, walking into the pits willfully, not resisting. You know, it's almost a belief that if I am going to be compliant, they're eventually going to see what a nice guy I am. They're going to say, you can go, you listen to us, you know, and no, it doesn't happen. So that our approach is very collective. We do have a collective conscience, and that, you know, unfortunately didn't work particularly well, except for the few partisans out there who fought. But, you know, ultimately, I do think we have to use the law. Some people will hold it against us. I do think we should not attack Muslims as a group because it would be incorrect, or just we shouldn't attack Germans. There were Germans who were helpful, even though they were extremely small number. There were Ukrainians who helped Jews. They were extremely small in number. But we need to target more the hatred. Now, the hatred, the problem is, of course, in the Islamic world, where let's say you have 2% of the population, the figure I've heard, that's genocidal. When you take 1 billion people, that's a large amount of people, right? But I think we need to be careful, and ultimately, you know, that ultimately we can go to sleep at peace with ourselves, that we have not committed the same crimes against humanity as they, because we followed through on commitments to justice and equality, and certainly not all of us Jews have done so, and many of us have fallen short, but I think we should still follow that path, and it is effective, because, you know, after all, the Genocide Convention was a Jewish man's birth child. You know, the equal protection laws in this country, of course, blacks were instrumental, but Jews were as well. So I do think we should continue that policy, but Israel is a major, major safeguard that we have that we didn't before. Yes, Noreen.
So what I'd like to say that this is, you know, I'm not a legal scholar, and so I would not offer anything concrete or useful. But what I would say is that free speech is the sacred cow of American life. And the coming out against free speech is a very risky strategy in the context of the United States, particularly in the academy. But not only in the academy, but I would say that I can't envision a situation in which a free speech position will not triumph in academia. And in fact, efforts to limit some of the worst hate speakers generally backfire. There was this famous Irish poet that was invited to, I forget his name, he's a very anti-Semitic guy who was invited to speak at the literature department at Harvard a few years ago, and people were upset. I mean, he was really a jerk. And so the department canceled the invitation because he was offensive. So there was a big brouhaha about free speech. He was invited to speak at the university. And the brouhaha generated hundreds and hundreds of people in the audience. You have this kind of thing every time we had an event at Yale. I live in New Haven, that's why I say that. And so, a couple of weeks ago, somebody came and it draws the hundreds. I mean, it's one of those things that and if you try to fight it, it's not a winning strategy. It's not like I have a solution, but I'm saying at Fordham we had Norman Finkelstein coming, and we didn't do anything. The faculty didn't do anything, and I think the result was a much, much, much lower attendance. Not much ado about nothing. The only people who came were, the Muslim Student Association who invited him, invited a Jew to say things about the Jews, which he always complies. But but it's kind of one of those things that that it's a the sort of strategy. I mean, I can't see myself advocating a non-free speech position. It's admitting defeat from the outset.
Right, I agree with you, and that's why I think the approach to take, the one I've taken, is it does not diminish free speech. Right, that here, the way that I did the talk today, the way that I've approached it is that here are countries that have commitments to free speech just as strong in their constitutions as the U.S., and they allow for the regulation of hate speech as well. So definitely not coming out against free speech. We don't want to do that. First of all, it's not in me, and I believe it. And second of all, to say that this would be an exception, just like copyright laws are an exception, obscenity laws are an exception, trademark violations are an exception. This is just another one that we should have.
But I think the problem with it, Alex, is that anti-Semitic speech is so prevalent. It's not like, by focusing on the KKK, I mean, Charles is right here, Focusing on the KKK and a bunch of right-wing nut groups, it's very simple. I mean, it's not, they're not. But when you have so much virulence coming from different groups, different individuals, not groups, where do you draw the line? I mean, the Protocols of the Elders of Zion, is that the defining thing, I mean, I don't know.
Well, one place to draw the line is where the statements are not opinionated but factual. So, for example, in Germany, in France, you can have Nazi symbols. If I come into class and I'm talking about William Shirer's book, The Rise and Fall of the Third Reich, and he's got the swastika in there, no one's going to take me to jail. And if I have an opinion and somebody comes in and says, I hate Jews, they're all a bunch of slime and whatever, that's not actionable. It's opinion. The problem occurs when it's factual. There is no Holocaust because that demeans, it makes us all a bunch of liars, and it's something that's analogous to defamation. People who oppose this will often say, well, first of all, that's not constitutional, and I don't want to go into the details of that because that really is technical, although I'd be happy to talk about it one-on-one because that has to do with this precedent going into a public figure as New York Times, we take too much to explain. But then I say, well, but you don't want to do, I mean, I talked to scholars, right? I've debated Jeff Stone at Chicago was very much opposed. Rodney Smollett at Yale, I debated. I've debated Nadine Strauss in Texas. I mean, I've debated lots of these characters. And you're absolutely right. You know, I'm first of all not going to convince them, but at least hey, you know, they're willing to listen. I appreciate that. So I think that it's worth at least putting forward this argument with Norman Finkelstein. Well, you didn't stop him, but DePaul stopped him. DePaul stopped him. They did not give the guy tenure. Now they said, well, you know, he's too vitriolic, he's too offensive in the way that he attacks individuals. He's too ad hominem, but they stopped that guy, right? And what did he do? Very shortly after they didn't deny him tenure, he went and met with Hezbollah and he said they were freedom fighters in the Middle East. I mean, he showed his face. So that was not low key. DePaul's stance against Finkelstein was not low key. And yet, I would say DePaul won, Finkelstein lost. He's not getting any academic position anywhere in the United States. I mean, I can't imagine it happening.
It's odd, though, recently came out with some statements that were considered too pro-Israel for the BDS people.
Wow, I didn't hear.
Yeah. Finkelstein now is on the right wing of the BDS movement.
I don't know if that takes a whole lot. So fact instead of opinion, lots of hatred. That's totally allowable. And we must live with it in society. So, but it's just nature of democratic society, but not where it's factual. You had a question. You had to stay with the new. You're next.
Yeah.
I think she had a question first, and then
I was going to say that and this is an impression, but I would guess that.
I'll call on you for sure. But let me just go on. Yeah.
Okay, my impression is, and it's an impression, and I don't have the data for it, but my hunch is that it's probably an accurate statement, is that many Jews don't perceive much anti-Semitism in the United States. And I speak from trying to actually organize some group of faculty at Fordham around what I considered problematic, and the response was, well, we don't have a problem here, which I found very interesting. So you're talking about wanting political activity where you have perhaps many people who don't see much of a problem. I remember, I'm a child of Holocaust survivors as well, and in San Francisco when my parents trying to organize Holocaust survivors to give some voice to their experience, to put monuments up, etc., most people were frightened to make noise. They wanted to go below the radar and not be seen as problematic. So we, in a sense, may be our worst enemies, is what I'm saying. I mean, I don't mean that literally, but I don't think that there is necessarily a taste for a lot of political action, which is essentially what you're advocating when you talk about Sharpton and Jesse Jackson, etc. I don't think there's a real taste for that in the general Jewish community. Now, I'm surmising this based on anecdotal experience. I'm a researcher, so I don't think to make those kinds of draw those conclusions, but I'm sort of laying it out there. And as long as we don't recognize it when it occurs, and I think it happens in many little different ways, often, it's not the problem. We see it when we talk about Hamas, Hezbollah, it's going on in the Arab world, but we don't talk about what goes on in our own communities.
Right. Well, part of it is that we have to stand up. Mr. Charles, you want to answer that? Yeah, go ahead.
A very brief intervention. I just spent 5 days with Daniel Simone, a French Parisian intellectual, he's a mathematician, a psychoanalyst, and a philosopher. He's an amazing guy. And he sort of unpacked the whole kind of issue in this talk in Montreal, which I never considered before. He was looking at the psychological effects of antisemitism. And he was arguing that Islamophobia, first of all, at one level, is the West's rejection of the Muslim world. And the Islamophobia is that the Muslims are perceived as hordes of mobs, and we are afraid of them and we want them to be quiet. The Jews come along, some Jews, and they say, hey, there's a problem in the Islamic world, and the reaction is to keep it quiet. And the animosity is then directed towards the Jew. It's sort of his philosophical. Then he sort of was saying that Jews in the United States have had success. Some of them are in institutions where their parents and grandparents would never have dreamt of going. There's fear, there's guilt. And when these issues are put in their face, they acquiesce, they're silent, and not only are they silent, but they become angry at the messenger of the issue.
It's also called passing. African Americans have a term for passing.
Anyway, so then I just spent 5 days with it. So So there is this whole body of literature in the French context on these issues, which I never knew, but it's fascinating.
So two things. One is that in Germany also there were many people, not all, because many people left, including Einstein, and immediately realized what was going on. In fact, a large group of Jews left immediately. It's also a country where many Jews were in power and they could be taken out just like that. You know, so I wouldn't take it for granted that Jews are in high political offices to think that it's not going to happen anytime soon, but in decades, if somebody were to come to power with you know, true anti-Semitic ambitions and was able to gather people in, and actually, quite frankly, if that has any potential, it's going to come through Farrakhan, because he's really the strongest in terms of potential for politics in the United States, taking that to a new level, not only in terms of anti-Semitism, but again, you know, he's very opposed to racial mixing and all sorts of different things. Then, you know, so we have to be realistic. We need to stand up to issues where we can. I totally agree with you. I think Jews tend to be much more able and willing to stand up for other groups and to say, you know, to think that we don't really need that as much for ourselves. For example, in Title VII, the anti-discrimination law, Jews were supposed to be in there, believe it or not, but Jewish groups said that they wanted to be taken out of there because they said we've done well enough in this country.
Here's my data.
So, you know, there's Scrutiny as a researcher from some.
But we have done very well in this country. I mean, I think it would be, we have to be,
Right.
you know, we have to really acknowledge that in the United States, this has been the, you know, the golden diaspora, you know, the greatest golden diaspora in Jewish history. So this is not, Jews have done really well here. So the thing, it's not, the threats at the moment don't come from domestic.
Right, so that's another great point. And I wanted to go that as a second route. So one is to defend where we need to. The second one is that in the counter argument, which you just made, it was stronger than I had wanted to, and I'm glad that you did, is that that we should not take it for granted that we will remain in this position forever. You know, it's easy to think that this is the way it was, and it's feasible that Jews in other countries thought something similar. And Germany is a great example. That surely we, who were veterans in World War I and who are so established, will not seek will not be so undermined by these anti-Semitic parties. The Germans will wake up. But we shouldn't take it for granted. And I do think that having laws that prohibit hate speech towards Jews and other groups is critical, because it continues to communicate that we will not tolerate, we will not consider this to be legitimate forms of speech. We will not say, oh, well, let social Darwinism have its course, which is with the marketplace of ideas doctrine in the First Amendment, which Alvin Wendell Holmes came up with before. Well, really, it's actually Mill's idea, the philosopher Mill's idea, that Holmes adopted, this idea that in the marketplace of ideas, the truth will triumph. But if you look at Holmes' other writings, Holmes is a social Darwinist. He doesn't believe there's anything objectively called truth. He thinks what happens is that the stronger social movements have their way, and whatever they say is truth is truth. He's very clear about that. And so if he actually says in a case called Gitlow, a First Amendment case, that if a proletariat totalitarianism were to come to power, then it should have its way. And that's what happened in Algiers with Islamicists winning in the democratic elections and trying to put down democracy as a whole, and Algiers saying, well, no, that's not, we're not going to have that, we're going to revoke those election results. So I think we shouldn't take it for granted. We're doing so well. We should be grateful to this country, and we should forever be grateful to this country. I'm an Army officer. I served in the U.S. military for 9.5 years, and we should, for sure, not see this in some sort of a clouded way. But we should also be cognizant of the fact that it might not be forever. And we should be cautious about future generations as well. You had a question.
Yeah. My question goes back to the different approaches in America versus Europe. And so what I've been sort of perceiving with your definition of hate speech is that there's 3 different levels almost. There's the speech that dehumanizes the other, and then there's the speech that like incites violence, like immediate violence, like in the Black court, I forget.
Virginia v. Black.
Virginia v. Black. And then you were talking about in like speech that incites genocide. So those are like almost 3 different levels of hate speech, if you. That's just how I'm taking it right now. And so I'm wondering how you would put this together with the recent, and in what you think the U.S. government should be doing with the recent subway campaign ad in New York City that was, I forget the exact words that it used, but it was like a private organization that put up subway ads that used, I think, the term like take the civilized path, like support Israel, and it dehumanized, it like made the Palestinian, the terrorist, whatever word it used. I'm not sure it used anything. It was just like, take the civilized, and there was a huge brouhaha over it, and people found it offensive, but no one took it down, and there was even a woman who was arrested in Times Square for defacing it, just because that's against the law. But this particular poster or advertisement campaign that some people felt counted as hate speech wasn't against the law. So I'm just wondering what you think the U.S. government should have taken a different stance on that, kind of like, would that have been permitted in Europe, that particular subway
So the
campaign?
dehumanizing aspect of it will go nowhere in the United States, because that has to do with violations of dignity.
Mm-hmm.
And there's a German, the very first part of his basic law, the first section, protects dignity rights.
Mm-hmm.
There's some movement of that in the United States. The Supreme Court talks about it. For example, it spoke about it in a case called Lawrence v. Texas, which protected the intimate rights of gays to engage in intimate contact. It spoke of dignity rights. It speaks about it in different contexts, but it really, Justice O'Connor has spoken about it as well, but it has very little weight. So dehumanization will gain no traction in the U.S. Where it might gain traction is these anti-incitement laws, and the genocide laws that Ted Charles proposed, and just laws where there's really an instigation, an intentional instigation to get people to commit crimes against humanity or violence against individuals, and on the basis of hatred, where you could have laws that either are separate laws that are very specific about that form of instigation, as opposed to another form of instigation, like let's just go steal some money, and here, because this person's a Jew or black, or
Instigation against a group.
an identifiable group, that's right. And I do think that would work. The other type is group defamation, where you say something that is false about an entire group of people that harms them. You have to prove harm, so it can't be simply, we don't like it, it hurts our feelings. That's never going to go anywhere. It wouldn't go anywhere in any European country that I'm aware of. You have to actually hurt their dignity in Europe, and here you would have to hurt their reputation and ability to get a job, and ability to retain a job, that sort of thing.
What's the difference between hurting dignity and hurting your feelings? How do you legally delineate those two?
I don't know how Europeans do it, though, and again, I don't think it would work here, but dignity, where here what would work is that you would actually have to have a cognizable harm. That somebody lost his or her job, it caused severe emotional distress, that's just a very difficult thing to prove, and maybe that would be sort of a tort. Richard Delgado's proposed that.
Take the particular ad, the actual text of the ad is the more, there were several, but the one I think you're mentioning, it says, in any war between the civilized man and the savage, support the civilized man, support Israel, defeat jihad.
Mm-hmm.
Right, so to me that doesn't look like hate speech at all. I don't see any instigation, any intent. Right, so that just looks like free speech. The same thing with, I don't know if you ever saw the cartoons, the Danish cartoons.
Yeah.
Denmark thought those were not instigations. I've looked at those cartoons. They don't look like instigations to me.
Mm-hmm.
They just look like a bunch of opinions. The same thing on the flip side, to make sure that people know that by commitment is equal. Right, the boycott and divestment movement also seems to be like a free speech movement. I think more speech, in fact, counters that form of speech.
Mm-hmm.
But what I'm talking about are really extreme situations that have, in other places, drawn democracies into autocracies. And that we need to be cautious but not take for granted that democracy is forever.
Well, let's
If you could, we've hit our, Charlie, good. We've hit our bewitching hour.
Great job, Alex.
Great job.
Thank you so much. Thank you for coming.
Alex, thank you. It was amazing sessions. Thank you. Just very briefly, the next session is November the 8th. We're having, I think, a very interesting speaker. His name is Haris Rafiq. He's a Muslim. He's an old friend, by the way. And he does work on radicalization. He was actually quite radical when he was a young person in northern England. And he works with young kids who are radical to kind of bring them back into the mainstream. And he's an advisor for the British government, both the Labour and the Conservative governments, on dealing with Muslim minorities in Europe and radical Muslims. And he's a serious thinker, interesting experiences. I think he'll do a very good session with us. So November the 8th is in 2 Thursdays from today.